Oh, no, I'm being told he stuck his finger.
Right out of the gate, this courtroom drama explodes with tension. Before we even get formal introductions, the judge is already dealing with what appears to be an attempt to sabotage a drug test. And that matters more than viewers might realize. In cases involving probation or plea deals, sobriety compliance is often one of the biggest factors courts use to determine whether someone is serious about rehabilitation. So, when someone appears to manipulate or invalidate a urine test, judges see that as dishonesty, not just a technical mistake. Here's what's critical: this isn't just about a dirty test, it's about trust. Judges, probation officers, and treatment programs rely heavily on truthful participation. Once trust is broken, the court often assumes deeper problems are being hidden. And notice how quickly Judge Boyd reacts. This tells us she already suspects a pattern, not a one-time issue. And let's ask the audience here. If you were the judge, would you see this as an honest mistake or a deliberate attempt to dodge accountability? Because the decision about to unfold will determine whether this man walks into treatment or prison. And trust me, this courtroom is just getting started.
In water and in the testing, which I find very suspicious. Yeah, no, nobody does that.
And I was trying to take
Court is calling 2023 CR 0889, State of Texas versus Stephen Wayne Walbarker. Could I have parties announced for the record for the state? Defense.
Ron Ross for defense.
Are you Stephen Walbarker? You entered a plea on June 15th, guilty to count 2. According to the plea bargain agreement, punishments be assessed at 8 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, we have, Judge, and by the way, it's a capital H.
Ah,
Yes, and state is silent, Judge.
all right, if y'all want to, oh yeah, it is a captivate. Okay. And the state is silent. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
We have, judges, just one correction or
Yes.
in the TAP evaluation down about toward the end of it said that he's continued to use marijuana since he was arrested, and he says that's not true. He said since he's arrested, he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because
I know.
he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
I just did, when there was no urine, ma'am, I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court.
I can.
So, counsel, anything you wish to say on behalf of your client?
Judge Boyd's reaction here reveals something important about courtroom culture. Drug testing isn't optional theater. It's a core tool courts use to measure progress. When someone interferes with testing, the court often assumes the person is hiding active substance use. Defense counsel tries to soften the situation by pointing out employment struggles and possible cognitive limitations, hoping to frame the defendant as someone needing support rather than punishment. But notice how the judge pivots immediately to accountability. She essentially says, treatment or prison, your choice. This is actually a powerful judicial strategy. By giving defendants a choice, judges shift responsibility onto them. If the defendant chooses prison over treatment, the consequences become self-inflicted in the eyes of the court. And here's a key question for viewers. Should courts prioritize treatment even when defendants seem dishonest? Or does repeated dishonesty justify harsher punishment? The tension between rehabilitation and accountability is one of the biggest debates in criminal justice. And this case is a perfect example playing out in real time.
Judge, I would say that he's 55, and I think his report, he's got child support obligations. He looks, I don't know that he's not diagnosed as mental slowness, but it seems to be. And his jobs, he's not had real good jobs. Right now he works at a cook, but he is employed. He's been employed, and I don't know that at this point in time, sentencing the prison is going to really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I
I
think it's kind of
understand.
ridiculous what he says, but. keep him
Oh,
outpatient.
I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either he's going, you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years. Which do you choose, prison or treatment?
I'll take treatment.
All right, the court will sentence you to 8 years in the prison. Thank you. Suspended and probated for 8 years. Take in consideration 2023 CR 0888. Got to sentence you to safe P. Followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors.
Now we're seeing how detailed probation conditions actually become, and many viewers don't realize how strict these rules are. Employment verification, restrictions around minors, drug testing hotlines, community service. These conditions aren't random. They're carefully structured to reduce the risk of reoffending while forcing stability into someone's life. Notice especially the prohibition on working with minors or in home healthcare settings. That tells us something about the underlying concerns in this case, even if details aren't fully discussed here. Judges often craft restrictions based on patterns or risks associated with the offense. But here's the challenge. Probation isn't easy. Missing check-ins, failing tests, or ignoring employment requirements can quickly land someone back in court. And probation violations often send people to prison faster than original charges. So let me ask viewers, do you think probation is a second chance? Or is it actually a setup that many defendants are bound to fail? Because compliance requires discipline, resources, and support, things many defendants struggle to maintain.
There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, anything else?
Anything else you need from the court to be successful?
Someone might-
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yeah, yes, ma'am. Oh, yes.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand? We can go off the record. Mr. Wahlberger, here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine 1, your level of truthfulness, and 2, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right, good luck to you.
This private moment off the record gives us rare insight into how judges actually think. Judge Boyd isn't just punishing, she's explaining her logic. And her reasoning is clear. Dishonesty about sobriety signals a deeper addiction issue requiring structured treatment. Many viewers assume judges just hand out punishment mechanically. But here, the judge is actively trying to steer the defendant toward recovery, even if it feels harsh in the moment. Inpatient treatment removes distractions and forces accountability. But here's the emotional twist. Sometimes defendants sabotage tests out of fear, shame, or addiction-driven panic. Addiction often pushes people to avoid consequences in irrational ways. So here's something to consider. If addiction is influencing behavior, how much responsibility should courts place on personal choice versus medical treatment? It's a tough balance, and judges have to make these decisions quickly with imperfect information.
21 CR 5216, State of Texas versus Delphina Spiller. Can our parties announce for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Valerie Headland.
And are you Ms. Spiller?
Yes, I am.
Showing you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Delphina Spiller who was placed on deferred adjudication in 2021 CR 5216 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 10th, 2021 for a period of 5 years? Is that you?
Yes, that's me.
State?
Violated condition number 5 in Bexar County, Texas. The defendant Delphina Spiller did then and there fail to report to the supervision officer as directed for the months of July and August 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State?
Your Honor, we waive and abandon the other violations alleged.
Any objections?
No.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, I do.
Now we shift to a different defendant. But notice how familiar the pattern feels. Failure to report, probation violations, and escalating consequences. Missing probation check-ins is one of the fastest ways defendants land back in custody. Defense paints a sympathetic picture. Serious medical issues, hospitalizations, family crises. And these explanations are believable. Real life can spiral quickly when health problems hit. But from the court's perspective, communication is everything. Judges repeatedly say the same thing. Pick up the phone, call probation, notify the court. Silence is what triggers warrants. And let's engage viewers here. If someone is dealing with medical emergencies and family chaos, should courts show more flexibility? Or does responsibility still fall on the defendant to keep probation informed no matter what? And because the judge now has to decide whether compassion outweighs repeated violations. And that decision will change this woman's future.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, I do.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not a proposed agreement. We were going to recommend 5 years, and I believe the defense would like to ask for an alternative to that, Judge.
All right, defense, what are you requesting?
Judge, without going into so many details and background on this, and certainly not to offer excuses, Your Honor. I did meet with Ms. Spiller for a long time last week. She has had some serious health issues starting about the time that she did last reported to probation. And it had her in and out of the hospital from around June, July of 2022. September, they finally diagnosed her. And then she went septic and went into the hospital for 3 weeks in November. I don't think she was in a right frame of mind at all. I did ask her, why didn't you just pick up the phone and call probation, call the court? She was eventually picked up because, well, she was in Spring Branch. And then after she resolved some of the medical issues.
Was she supposed to be in Spring Branch?
No, Your Honor. Her mother-in-law lives in Spring Branch with her children. And her mother-in-law was administering the IV antibiotics and everything that she was going through. and her mother actually has custody. Is it one daughter
Yes,
or
it's
two?
one-
Just
one
one daughter. Because of a very serious incident that happened with her eldest daughter in 2017. Ever since that date, I think Miss Fuller's life has spiraled out of control.
And has she picked up any new offenses since
That's
she
the
was?
problem. She has two new, excuse me, number ones out of Comal that are for misdemeanor charges that are from September of 2022, all along the same kind of time frame.
And what are those charges?
I think fraud, use, possession, less.
Failure to
than five-
identify.
Failure to ID. There's an offense report in the summary.
All right, and so she has fraud use, and I will tell you that in this plea bargain agreement with the case, they took into consideration fraud use cases. And so I have before me a person who's not reporting and is alleged to have picked up new fraud use cases and didn't pick up the phone and call probation.
Yes, Your Honor.
This is where sympathy starts running thin in the courtroom. Even with medical issues, new criminal allegations seriously weaken the defense's argument. From the judge's perspective, it suggests ongoing risky behavior rather than isolated hardship. Judges look for patterns. When probation violations are combined with new charges, courts often conclude supervision isn't working. That's when prison becomes more likely. But here's the nuance. Association matters. Defense suggests she wasn't the primary offender, just present with someone involved. Still, probation often prohibits association with criminals entirely. Let me ask viewers, should someone be punished simply for being around the wrong people, or should courts look deeper at actual involvement? Because for many defendants, separating from harmful social circles is one of the hardest parts of rehabilitation.
She knows not to just stand before you and make excuses or say it's a mistake. She knows that. But in the Comal report, at least, she was with a person that got charged heavily with other items and issues, and she was coming out of the Tractor Supply. So there's a paragraph in there that addresses her. The majority of the report is for the person that she was with.
All right, and the person she was with, does he have criminal charges?
I would imagine so, based on that.
And she's not supposed to be around people who have criminal charges.
Yeah. I would ask Judge, this is her first MTR. And the charge is a second-degree felony, her underlying, from 4 to 200. It was 5-point-something grams of meth at the time. So if that's any consolation, I would beg that she be allowed to continue probation. At worst, revoke, sentence her for the convictions. And I think she's on the bird. And then place her back onto probation so that she can seek additional help and support. She is with her sister now, back in San Antonio. I think her sister is a good influence and is helping her. She also suffers from diabetes, Your Honor. She's having vision loss, so she can't read the paperwork that I give her. She had a doctor's appointment scheduled for July 27th that she missed because she was taken into custody on this case. That's why I asked the court to bring her a little bit quicker. So I would just ask that she not be sentenced to TDC. I realize there's not really an alternative placement for her, like treatment, because she has charges pending in Comal that I can't really do anything. I don't have any influence in those cases. So we're just asking the court to, if at worst, sentence her, revoke her, but put her back on probation since she's never been to TDC.
All right, Ms. Spiller, there are consequences for actions. I am going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. There's a $500 fine, time and money rent concurrent. If you would like, I can ask that you be placed in the therapeutic community. I have no jurisdiction for you to be placed in the therapeutic community. You'll have to ask for it as well. But the therapeutic community is helpful in any type of drug issues that anyone may have. Would you like me to request the therapeutic community?
Yes.
And just like that, the decision comes down hard. 5 years in prison. Judge Boyd emphasizes consequences for actions, making clear that probation is an opportunity, not a guarantee. But notice something important. Even after sentencing, the judge recommends placement in a therapeutic community. That means treatment is still part of the plan, even inside prison. Courts increasingly recognize that addiction issues don't disappear behind bars. This is a stark reminder. Deferred adjudication and probation offer chances to avoid prison, but failure to comply can lead to severe consequences. Viewers, what do you think? Was this outcome inevitable? Or should the court have given one more chance? Because now, the stakes shift entirely from rehabilitation in the community to survival and recovery within prison walls.
All right, I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? Because this is I'm sorry, you need to speak up.
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You're gonna have to do better, okay? All right, thank you. 22 CR 0491. State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense?
Jay Moritz, Your Honor, from Mr. Adame.
And are you Mr. Adame?
Yes, ma'am.
Is your last name Adame or Adames?
Adamas.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeffrey A. Adames who was placed on community supervision for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Violated condition number 28 on or about the first day of May 2023 in Bexar County, Texas. The defendant, Jeffrey A. Adames, did then and there fail to comply with the rules, regulations, or instructions of the Lifetime Recovery Substance Abuse Treatment Facility, and that the defendant prematurely departed the program without permission in violation of condition number 28.
And Bashan, he's going on 28. To that, how do you plead? True or not true?
True.
State?
And the state would waive and abandon the further allegations.
All right. Did you understand by pleading true to violation of 28, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 28?
Yes, ma'am.
Counsel, any objections to the waivers of the other allegations in the motion?
No, Judge.
All right. Is there a recommendation?
And just like that, the decision comes down hard. 5 years in prison. Judge Boyd emphasizes consequences for actions, making clear that probation is an opportunity, not a guarantee. But notice something important. Even after sentencing, the judge recommends placement in a therapeutic community. That means treatment is still part of the plan, even inside prison. Courts increasingly recognize that addiction issues don't disappear behind bars. This is a stark reminder. Deferred adjudication and probation offer chances to avoid prison, but failure to comply can lead to severe consequences. Viewers, what do you think? Was this outcome inevitable? Or should the court have given one more chance? Because now, the stakes shift entirely from rehabilitation in the community to survival and recovery within prison walls.
Yes, ma'am.
The recommendation and the agreement of the parties, should Your Honor choose to accept it, is to deny the motion and alter and amend the defendant's conditions for SATIF with aftercare, and have the defendant complete that drug treatment.
All right, is that the
Yes,
recommendation?
my understanding is that it was held in abeyance if he didn't comply, and that he is agreeable to it and wants that treatment, Judge.
All right, probation?
Yes, Your Honor. The recommendation would be for static with the aftercare, and if he does not want to do that, I recommend revocation.
All right, you'll raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand if you'll state your name for the record.
Jeffrey Allen Adamas.
All right, why did you leave Lifetime Recovery?
My father was diagnosed with brain cancer. I had to help because I get disability retirement. So he was gonna lose his house. So I decided to, my two brothers weren't working. So I decided to leave so I can use my disability retirement to help him out with his, till he had the surgery. And then when he went to recovery in Universal City, he started the recovery. My brother's got a job, so I was able to leave. And I was working on trying to get some money so I could turn myself in, which I did in the 13th of last month.
Yeah, why don't you pick up the phone and call probation and say, my father has cancer and I need to help him?
I freaked out. I mean, I was just, I was just real distressed. I mean.
No, how old are you?
I'm 50 years old.
No, it's easy to pick up the phone and say, my father has cancer, I need to go help them. And then if probation would have said, no, you can't do that, then you know what would have ended up happening? I would have got an email from probation and they would have sent it to me and said, his father is ill, he would like to go be with his father. And then you know what I would have said? Have him come in and we would have discussed it. And maybe I would have let you take care of issues with your father. You are on probation. Probation is a contract. So even though your attorney, the state and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
I understand.
Do you understand?
Yes, ma'am.
So now what has happened? You're still in the same situation you are. Now you're starting all over. When lifetime recovery, you probably would have been finished with it by now. Now, instead, if I follow this agreement, you're going to be in custody and wait for transfer to SATA. All because you don't pick up the phone and call anybody. And lifetime recovery and all of these treatment programs are supposed to teach you how to deal with your problems. And dealing with your problems are not supposed to be, I'm not going to follow the rules, I'm going to throw my hands up. What if I had a problem and I said, in the middle of this, I have a problem and I just leave, I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home, you know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. I'm not just going to leave. And then everybody's like, what do we do now? And in your case, when you just drop off the face of the earth, you know what the what do we do now is? File a motion to revoke. All right, how much longer did he have in lifetime recovery? Will lifetime recovery accept him back or no?
Your Honor, that would be something I have to research.
All right, so this is what I'll do. If you want, I will sentence you to prison for 2 years, or I will send you to SATA. And if lifetime recovery will accept you back, then it'll be lifetime recovery if they accept him back. If they won't, he'll go to SATA.
This might be one of the most powerful teaching moments in the entire session. Judge Boyd uses a simple analogy. If she walked out without explanation, chaos would follow. The same applies when defendants disappear from programs. Probation is described perfectly here as a contract. Breaking it triggers legal consequences automatically. The judge isn't just scolding, she's demonstrating how systems rely on communication. And notice her compromise, prison or treatment. She still offers a path focused on recovery. That shows balance between accountability and rehabilitation. Viewers, here's something to think about. How many people in the justice system fail not because they're dangerous, but because they panic or don't understand how to navigate the rules? Because this judge seems determined to teach lessons, not just punish mistakes.
At this point, I really don't think lifetime recovery would be the best option. I
Okay.
think we would need something a little more structured.
All right, so it will be SATA. So you can go to prison for 2 years, or either you can go to SATA. Which would you prefer? All right, I'll deny the motion. Alter and amend conditions.
Yeah.
To include SATA. Followed by aftercare. And I'm going to want the UA hotline upon release. And that's to be until further notice. Is there anything else you need from the court so that I won't see you back up here again with the motion to revoke? Probation, is there anything else he needs? All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Tonight's courtroom session shows 3 different defendants, but one consistent theme: accountability and communication decide outcomes. Judge Boyd repeatedly offered choices: treatment or prison, compliance or consequences. And every defendant's fate turned on how they responded to those choices. In the first case, dishonesty about sobriety led directly to inpatient treatment. In the second, repeated probation violations combined with new charges resulted in a 5-year prison sentence. And in the third, failure to communicate nearly sent a man to prison, despite his attempt to help his sick father. The bigger lesson: courts increasingly push treatment over punishment, but only when defendants demonstrate honesty and effort. Probation is an opportunity, but one mistake or failure to communicate can undo everything. And now we want to hear from you. Which case outcome felt most justified? Which one surprised you? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.